You get started. Welcome again, Scott. Thanks for coming today. We really appreciate you and your work in getting this legal update together for us. I know that our members are very hungry for some information about what is going on right now and the information about the updates in our lease and how that could affect their businesses. So without further ado, welcome, Scott. We're so glad that you're here.
Thank you. Good to be here. Well, hello, everyone. Sorry I can't be there in person. I always enjoy coming to Arkansas to visit with you all, and I appreciate the invitation to speak to you even virtually. I know it's been a crazy time for operators in the middle of this pandemic. I appreciate all your hard work and fighting through the craziness. I wanted to sort of discuss multiple topics with you today, certainly address the issues relating to the pandemic, something going back to even your rental agreement and comfort regarding your use of your rental agreement. And then I also wanted to save time for discussion of the CARES Act and the elements within federal law that would be advantageous to operators to make sure they understood and knew about for financial support for their businesses during this time. So let's sort of get started. Now, what's interesting is if we go back now to March, beginning of April, almost all the phone calls I was getting started with this issue of the state of emergencies that were being put in place by the different states. Even before we got to the shelter in place, you would have the states impose these state of emergencies. They were health emergencies. We hadn't seen these in a lot of states. I mean, some of you have experienced this as a result of natural disasters like tornadoes and other storms, hurricanes, whatnot. California has a lot of these with fires and earthquakes, and sometimes it just has to, the state goes into a place where they seek to stop everything, protect all of its consumers, and one of the number one things that rolls out of a state of emergency issue is the pricing protections. And self-storage falls within that same broad language with relating to pricing protections during a state of emergency. So you have a state of emergency in the state of Arkansas. In fact, as you can see at the bottom of the slide, that state of emergency was recently extended June 2nd for an additional 45 days. And this pricing protection that's talked about in the statute provides for protection of not more than 10% price increases during the state of emergency and for 30 days afterwards. So I want everyone to be careful and aware of the fact that if they would typically have a rate increase to the units, as you might normally during this time of year, you're going to have to rethink that. Certainly limited under 10%. And there's sort of a number of gyrations that go with this state of emergency question and the pricing changes. You know, a general across the board price increase of less than 10% probably isn't going to alert anybody. But if someone's been in a move-in 1 month free and, you know, moves in for $1 and then jumps to $120 for their monthly rental rate, the question is that legal because their rate increased more than 10%? And it absolutely is, because it was based upon a contractual agreement that the discounted rate that they moved into was for the $1 a month, with an understanding that it would jump to a regular rate as part of the contract whenever that expired, 1 month, 2 months, whatever you had planned as part of your contracting. So one of the lessons I want to make sure you think about with respect to any discounting you're doing now is making sure it's clear that when that discount period ends, the price reverts to its regular rate, and the tenant understands that that's not a rate increase, but that's the agreement that they entered into with regard to the original pricing. As it applies to across the board pricing, you're going to have to stay under 10% or be prepared for some question of scrutiny as to whether the prices of your charges may be accelerated. So just that was the first sort of topic. We could talk about little gyrations of that pricing issue for a long time, but I want you to alert you to this issue and how you may deal with that in terms of investigations for pricing that exceeds that, and the length of the protection that goes 30 days beyond the state of emergency. We could see that state of emergency that would now certainly expire in the middle of July be extended later. You can always check the governor's office for their executive orders, and those constant rules and updates of things that are changing. So let's go to the next one. Again, I'm here with you now, not having to deal with the question of whether you were an essential business, whether you had the right to be opened, whether you had the ability to close your office and keep the facility open. There was a lot of stress over that question of what is an essential business because of the different definitions that were coming out relative to businesses, real estate businesses in multiple states. And unfortunately, each state executive order as to a shelter in place and what was an essential business was different. And you had to go through this analysis whether in your particular state you fell into the question of essential, not essential. Fortunately, we don't have to deal with those nuances right now. You have the right to open and be open as part of the lifting of the shelter in place rules. But with that comes certain obligations you have as a business owner with regard to opening your business. And as you can see here, pursuant to the governor's order, there's a number of obligations you have as a business when you're opening to make sure that you're protecting both your employees and your customers. And you can see from this list, and those of you who have read the executive order, limiting the number who can enter the facility at one time so that everyone can maintain the 6-foot distance. Well, of course, in a self-storage facility, a widespread area, you're not really worried about letting people into the property. You're not going to get 500 people in at one time. So the spacing issue doesn't bother me. Although in your offices, you may have a situation where you have marked out, like this talks about, 6-foot increments of someone standing in line, and the possibility someone would have to be outside waiting to get into your office if you had that many people in line. Issues concerning using disinfectant and keeping your areas clean, wiping things down, using the remote payment opportunities for your customers. And one thing you'll see here, as it mentions, is posting a sign at the entrance to the facility informing employees, customers, and congregants, others, that they should avoid entering the facility if they're sick, and maintaining the social distancing. You can get these signs anywhere now. I mean, a lot of these places have produced a lot of these social distancing signs. The statutory executive order element of the reopening in Arkansas would require you to have a posted sign. We have seen some properties be cited for not having signage, so we would recommend that you have the appropriate sign that meets the executive order now that you are open. And in fact, going a little bit beyond that, and let me sort of move to the next slide, is the Occupational Safety and Health Administration, or OSHA, has issued extensive information about what it is to keep your property, your business, for your employees, which is usually what OSHA is focused on, but as well as your customers, safe. And this talks about sanitizer and hand towels and masks and keeping people socially distanced and all these sort of rules. So this should be something that I'm recommending to operators have as part of basically a renewed maintenance list for your facilities, that you prepare a hygiene or sanitation or sanitized list for your facility, and your managers, as part of the operation of the facility, goes through that checklist of wiping down the touchpads, wiping down the gate area, doorknobs, maybe even units. And I've seen many of you advertise the fact that you're sanitizing your units. So but having a maintenance log might help you with regard to what I am concerned about potentially is the risk of claims primarily by your tenants, that they contacted the virus at your facility based upon your failure to maintain a hygienic facility, a sanitized facility. And your defense to that potential claim would be this maintenance list where you showed good faith effort to follow both the executive order and OSHA requirements, and you do this daily checklist, sign off on it, put it in the file, and hopefully not worry about it. It's going to be very hard, and some of you may have read my articles about this issue of contact tracing to prove liability for a business where someone might say they contacted the virus at this business. A one-off situation to say that they contacted it at your facility as compared to the dentist or the grocery store or somewhere else will be very hard. What we're worried about is mass transmission and a number of cases all tied to your location. that would be a potential liability risk for you as a facility and an operation. So having these sanitation procedures and maintenance procedures in place will help you with regard to the defense about that. I actually read this morning, Arkansas is one state that has provided limitation of liability protection in the health side of things, so that if someone gets sick at a hospital or other health location, that doctors and nurses are immune from liability. And it's really unique because that deals with the health professional protections with people claiming that they got sick, for example, in a hospital or a health area. We are looking to expand that protection to businesses so that your business is not subject to liability in case someone gets sick because of the difficulty of tracing the true location of the virus. That doesn't help you right now, and what will help you right now is having a system in place to maintain the sanitation and hygiene of your property. All right, let's move on to what you are dealing with now. Is you're back up in business and you delayed your late fees, maybe your denial of access, and certainly your lien process for a few months. And this has created a lot of sort of questions in our industry about the process of this delay you've taken in holding off on your lien sale. So let me tell you, from the legal perspective, I respect and appreciate the fact that while you were in a shelter-in-place order, that most of you, if not all of you, held off on doing your lien sales. It's sort of unique, and certainly I can speak to the issue in Arkansas as compared to other states. There was never a particular order that was ambiguous enough to say that your right of lien foreclosure against your non-paying tenants was protected during the shelter in place or barred or stayed. Whereas in other states, the ambiguous language of some of these executive orders that may have intended to stop residential evictions carried over to commercial evictions, and as well as commercial self-help remedies. When we all know in self-storage in Arkansas, as well as our industry, that you have this lien right of enforcement, this lien foreclosure right, which is a self-help remedy. You don't have to go in front of a judge. So it's not an eviction. You don't have to go through a court process. If you had to go through a court process, it probably would have been stayed based on the fact that many of your courts have been closed. But in Arkansas, you have the self-help remedy. So the issue of why you may not have proceeded to enforce your lien during the shelter-in-place period was potentially the argument that the tenant may claim that because they were sheltered in place, they couldn't pay you, they couldn't get to the facility to clean it out and move out. So there was a lot of anxiety over the potential defenses that could come up during a shelter-in-place situation. Very unique to our world, very unique in our industry. So for those of you who held off on lien sales based upon that anxiety that the tenant might have a defense to why they hadn't paid and why they hadn't moved out, I think you did the right thing. But now shelter in place is lifted, business is starting to come back, and people are free to go where they want to go. Is the question, can you charge your late fees? Can you overlock the units? Can you have your lien sales? And the answer is yes. There's no executive order or court order prohibiting your right to enforce your contractual and statutory rights of charging your late fees, denying access for delinquency, or enforcing your lien process. Now, let's go back to evictions for a minute. Some of you have tenants that you've terminated the leases and the tenants have not left. They are holdover tenants. So the dispute with that tenant is not about non-payment, which relates to your lien rights, but deals with the breach of the contract for not leaving after termination. Unfortunately, for those of you who've been in this situation, you know that a holdover tenant that's based upon failure to vacate after notice is not a non-payment default, and therefore you do have to go the eviction route. Problem with that, and the reality for you guys is the courts are essentially closed to the normal eviction process, even in a commercial setting. So you would file an eviction for a holdover tenant. The sheriff may not serve that notice timely because they are holding off on some of these service issues, or they just may refuse to do it completely. Even if they get served, the court is not handling these evictions in a timely manner because there's just too much else going on in the courts. In fact, some of the courts are still closed. So I would tell you, you have the right to do your lien sales associated with non-payment, If you are in a termination, holdover, eviction process, I might suggest to you to be as uniquely creative as possible with the tenant, cajole them, pay for the moving truck, uh, assist them with their voluntary move out, because if you don't and you are in a true eviction situation for a holdover tenant that won't leave, again, not a lien situation, but an eviction situation, you might be sitting with that tenant for a while based upon the status of the courts, because the courts handle evictions. So I hope that's clear. A lot of the stress of can I start my lien sales again is now open to you to do those lien sales for non-paying tenants. One other element of that discussion is the following. We recommend, and we've seen this, and many of you have talked about it probably amongst operators, the inclusion of a notice in your lien letters that if the tenant's delinquency is based upon COVID-related defenses, they've been sick, a family member's been sick, or they've lost their job and they're on unemployment, to reach out to you to work out basically a settlement and vacate solution. It would behoove you to work with those who have that potential defense relative to the question of the lien sale. Not that you have to, but if you have someone that responds back to you that the reason they're not paying is a COVID-related defense and provides proof of that by unemployment or by medical records, it's likely that you can hopefully work out a resolution for them to vacate voluntarily and work out some settlement as compared to go through the lien process. Now, you may have people that will say, hey, I had COVID, I had the virus, you can't do anything to me, do what you want, you have no rights. That's not true. They have an obligation to notify you if that's their position, and they have an obligation to pay their rent or work a settlement with you. It's not an automatic and complete defense to their contractual obligations to pay you. It's just an invitation in terms of the perspective of someone that's been impacted by the virus, that you would work with them if you can to resolution. So again, lots of other discussions about that's possible. Let's go back to the rental agreement, and I really wanted to just remind you and sort of address some nuances of new provisions that were added to the rental agreement over the last couple of years. You have an incredible board, incredible executive leadership that has basically whatever you want seems to happen, and I give a lot of credit to Bill Humble and his relationship with the governor and the governor's office to get things done that you guys want to get done. So one of the last things that was put in place was this protection for you that if you came across personal information in a delinquent unit that was subject to lien, and you found that information and the tenant didn't come forward to recover their property, that you had the right, in lieu of turnover of that information to a buyer at a lien sale, to simply dispose or destroy of that information after 45 days and not suffer any liability for the disposal of that personal information. So this can be done within a number of ways. One is you can do an inventory and inspection of the property once that tenant goes into lien. Again, it's not the 30-day trigger, but after 45 days for you to have the opportunity to inspect the unit, determine what might be in there that may be so-called private or personal information, pull it from the unit, have your lien sale. If the tenant doesn't come in and cure, so of course give them back that file and the files we find. You could then dispose of it. The other option is to notify the buyer that the personal information is in there, and as they move the property out of the unit, to turn those records over to you for you to dispose of them. And you have the right to charge the tenant for the cost of that disposal or shredding. So that was put in there as a protection issue for you. We saw tenants in different states make claims against self-storage operators that your disposal of their personal records caused financial harm to them, privacy, identity theft, personal information being out there, even with regard to medical records, whatever. And it became an opportunity for you under this statutory change, which ended up in your rental agreement, to go through, if you found that information, for you or the buyer to dispose of that information without any liability. So something for you to remember, certainly something that should be in your updated rental agreement. I know Arkansas, the association does a very good job of updating the rental agreements for your access, so you're working off of the most recent rental agreement. If you have an old rental agreement and it doesn't contain this information, it'd be the opportunity for you to contact the association and make sure you have the most updated rental agreement. Next is dealing with this issue of permissioning to communicate, fax, email, calling, text. It has become obviously essential in what is our world of now contactless rentals and contactless payments and contactless communication with our customers because of COVID, that you had this in your rental agreement and now you can really use it. So where you might be moving to this opportunity only to communicate with your customers via email or text to work out rental rate issues or late fees or other issues, including the lien notice, which could be sent by email. This provision in your rental agreement under the updated rental agreement provides that opportunity for you to get complete consent from your customer to communicate with them in that method. So you want language like this in your rental agreement. Again, contact this association for access to that information so that it's part of your current rental agreement. It's one of those things that we saw coming in terms of this virtual communication world. We did not know that it would become so essential in the world of COVID and the communication and contactless aspects of your business. But now you're going to be glad that you have it and your ability to communicate with your customer without physically seeing your customer. Next is storage of motor vehicles. This has been around a while, but it's important to make sure that you've included it in the rental agreement to match the update in the statute, which would allow towing of cars and boats and RVs after 60 days of default at your facility, rather than go through the lien sale process, which involves the transfer of title in the car, the boat, and RV for the purpose of selling it. This is a situation where you would have a right after 60 days of default to forego the lien process, still have to give notice to your customer an opportunity to cure, but after that 60-day period has gone by and the customer hasn't cured, that your right to simply have the vehicle towed away by a licensed tower. We've had this for a couple cycles in Arkansas. Again, thanks to Bill and his group for pushing that through. It's a solution to a frustrating problem that many of you had over the years to deal with the title transfer issue of cars and boats and RVs stored at your property. So this is an opportunity for you to deal with a resolution of that issue for non-payment and delinquency by having the vehicles towed. So if you can essentially sort of look at how you would handle it, you'd still send out your lien notice, but in fact, this lien notice would be converted to basically a towing notice. It would be an opportunity to notify your customer about the debt that's due, the fact that if it's not paid within 60 days, the car, boat, RV is going to be towed. Letting them know that if they pay within a period of time you've given them after the 60 days, 7 days, 10 days, 15, whatever, they could recoup their property, but after that it's going to be towed. So again, important to have in your rental agreement because it matches the statutory rights that you have under the Arkansas Self-Storage Facility Act. Next one is the cross-collateralization of storage units. We've seen situations where tenants will rent multiple units, pay rent on one unit, not pay rent on another unit, but because they've paid the rent on one space, they have access to the facility based upon their access to the one paid unit. We see this game being played with multiple unit rentals and sometimes a situation where the tenant intentionally gets multiple units with the understanding that they're going to default and dispose of property that's in the other units and just keep one unit. This allows you, by the cross-collateralization of the units, that if there's a default on one space, it's considered a default of all spaces and would allow you to deny access to the customer into any of its spaces based upon its failure to comply with its rent obligations as to even one unit. This also applies if you sell one unit and there's a debt owed on another unit. The proceeds from that sale could be applied to the debt owed on the other sale. You wouldn't have to pay out the proceeds to the tenant when they owe you money on another unit. You're able to basically move the funds based upon how many units the particular tenant has, and the debt obligation that that tenant has to you. So it creates a unified approach to managing a default situation where there's multiple units in play with a particular tenant. So again, something to have in your updated rental agreement, something that you would have if you have the updated rental agreement. So it's something for you to just make sure and double check that you have for your facility now in terms of your operations. All right, I'm going to move into a little bit now just with respect to some of the federal laws that went into place because of the COVID pandemic. And one of those deals with the extension of the Family Medical Leave Act, which would require payment to an employee based upon their inability to come to work because they were taking care of a family member or someone else in their family that they may have had the virus. So we are wanting to make sure that you understand that there was an extension to this Family Medical Leave Act, and it would apply through the end of the year, but there's an exception for businesses with fewer than 50 employees. Now that fact that you have an exception doesn't mean you can completely ignore the Leave Act rights of the employee. They can still seek both full-time and part-time that leave based upon the fact that they are seeking leave to care for others. The question is, you may be entitled to an exemption if you are a business with less than 50 employees. And the statute explains that if you are an exempt employee and you sort of go through the list of how this is handled, is you would receive the request from the employee seeking leave and compensation for that leave. You would have an opportunity to respond to that you are exempt based upon the number of employees in your business, as well as the fact that the absence of that employee may have a detrimental impact to your business, and you cannot carry on without filling that position during the leave time. So you could deny the paid leave under the statute based upon these exemptions. If you're a company that has more than 50 employees, you may have already seen this, you would have an obligation under the Extended Family Medical Leave Act to allow that employee to leave to care for their family. You'd have to pay them for a certain period of time for that leave period, and there's a calculable way of determining how much that person's to be paid during their leave. And one thing that you'll see if you do pay those leaves is tax credits. And I wanted to make sure that you understood that if you provided leave for any of your employees to deal with the COVID-related illnesses under the Extended Family Medical Leave Act, that there's another side of compensation for you for allowing that leave pay, and that is in the form of tax credits and payroll credits to your taxes. It may not equal what was paid to the employee relative to the leave under the statute, but it would be the other side of supporting credits back to your company for allowing that leave. Now, again, this is an extension of the Family Medical Leave Act, which applies to a person who cannot come to employment based upon the need of others. There are, in fact, sick leave pay acts that were also passed in April as a result of the pandemic that relates to rights of an employee to get sick leave extended if they have the virus. Again, exemptions apply in that place for 50 and under employees, as well as some of the other exemptions that we just talked about that would not require you to pay the employee beyond their employee benefits that you may have already had in place for PTO or personal leave. And you have to be aware, I guess the reason I want to bring this up is, and some of you have already experienced this during the bulk of the virus impact, that you had employees that would not come to work because they were sick or they had to care for others. And the question was, what was your obligation to pay those employees during that period? If you're a company greater than 50 employees, you may have already paid out these employees for their medical leave or for family medical leave under the Act. If you've done that, you have tax credits available to you. If you didn't, there may be reasons why you should have, and that would be something you may want to talk to your accountant about with regard to the qualifying leave obligations that you may have had to certain employees that took leave, meaning that you might owe some money still to those employees if they qualified or requested leave under the Act. So it's certainly something to think about. Let me move on. As well as the family medical leave and the personal leave for medical need provisions that were changed in the federal law, we of course had the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act. This is a situation where within the CARES Act, and it was a very diverse and significant legal change for businesses. Some of you took advantage to some parts of it. I want to address quickly some of the other elements of it so you know that there's monies out there for your business if you've suffered some economic harm during the pandemic period. The first one, of course, is the Paycheck Protection Program. I know a lot of self-storage operators that took advantage of this program. Initially, as we've described, it was the 75% towards payroll coverage, 25% towards mortgage or rent or other insurance expenses for your property, with the ability for that loan to be forgiven based upon your ability to prove that it went towards payroll and these other expenses. And there was a process of applying through your bank and the funding being provided to you, and then the opportunity again, and this is still to come, to apply for the forgiveness of that loan based upon the fact that you showed that you kept your employees in place. Some of you took advantage of that, some of you applied, and I've heard about different amounts for different people. So that was like the number one element of the CARES Act, was the Paycheck Protection Program. I want to go through a couple others that you may not have been familiar with, and something that you should think about if you need it with regard to funding that's available from the federal government. The next one is the SBA Express Bridge Loan, and these loans of $25,000 could be used waiting for funds from other loans from the government. It's a separate bridge loan that can be provided. It's still available. It's something that would be something that you could contact, especially if you are an SBA borrower, could contact your SBA lender about these express bridge loans. There's also the Small Business Debt Relief Program, another opportunity to extend your payment obligations with respect to any SBA loans that you had, so that you could take pull back from any payment obligations under your loan with your bank under the SBA Small Business Debt Relief Program, up to 6 months of forbearance with regard to this loan. So again, these are things that I want to make sure you think about if you have suffered an economic loss associated with your operations and involved with COVID-related impacts to your business. Again, these are things that if you are working with an SBA lender already with the Paycheck Protection Program, you may have already talked about these things. I want to make sure that they're on your list in case, as I fear, we might still see an economic slowdown in the next few months, and these are things that would be available to you to maintain your business or to defer your payment obligations under your loans while you are maintaining the operations that you have. There is something called the Economic Injury Disaster Loan Program, which is from $10,000 to $2 million with regard to an application relating to an impact to your business associated with the COVID virus. Again, it's through the SBA. Again, there's an application process. This falls within the same sort of program that you might see if there was an earthquake or a tornado or something that impacted your business and you needed these additional funding through this disaster. Low interest rates, very favorable terms with regard to repayment. Something to think about in terms of, again, a list of available loan opportunities for you as a self-storage business. You're all subject to this under the SBA and therefore could apply for these loans under the SBA. And then ultimately, in terms of some of these protections, is what we would call a loss carry forward tax basis protection. This is certainly something you could talk to your accountant about, but what it does is presumably take your losses that you may suffer this year or with respect to your business based upon the pandemic, and take those losses and apply them backwards to earlier years where you've had profits and taxes to balance out your tax burden based upon what you're suffering this year, and be able to assess that back a number of years back, as far as 2013, 2014, 2015, because it would affect your tax obligation and could create a credit for you with regard to your tax obligation going forward. It's a very unique element of the CARES Act, something that not a lot of people talked about. You heard more about the Paycheck Protection Program, but there's certain elements within the CARES Act that deals with tax savings and tax protection for businesses relative to COVID impact that would apply to your right to set off what might have been more profitable years, 2013, 14, 15, 16. So something to think about, something to obviously be aware of in terms of addressing this with your accountant. So one more of those financial benefits of the CARES Act. The last one is the CARES Act Employee Retention Credit. So this is a situation where you can't get both the Paycheck Protection Program and this retention credit. But if you did not take the Paycheck Protection Program to pay your employees, this is an opportunity that you get a tax credit per employee based upon the fact that you kept these employees during a difficult period of time in our economy. This goes through December, and you would receive that tax credit in terms of retaining that employee at your business. Again, one of the unique elements of the CARES Act that dealt with sort of tax implications relative to the operation of your business. So if you had to go through a difficult period now or through the end of the year, but retain your employees working at your facility, whatever that might be, this may be an opportunity for you to receive a tax credit associated with that opportunity. Sensitive to the time, I wanted to go to, and I know there's not specific questions that you're going to be able to ask me live here, but I just wanted to bring up a couple of issues relative to the operation of your business that I've received relative to the pandemic question. And it goes back to something we talked a little bit about earlier with understanding your rights pursuant to your contract. As there is no pursuant executive order that applies to restrictions in your self-storage operations, the only thing that creates sort of an umbrella liability for you is if you are open, the fact that you need to make sure that there's protections in place for your employees and for your customers, again, regarding the health and safety of the use of the property. We've seen a shift, therefore, to new technology, going back to the contactless part of Bluetooth access, of electronic access, things that would be sort of the next generation of self-storage technology relative to operating your property. And in doing so, does that greater removal for you from your customer create certain protections relative to COVID contact and virus? And the answer is yes. I mean, to the extent that there's less social interaction, less opportunity for your customers to be in the office, less need for you to be out on the property dealing with a customer during a lock cut or a lien sale, things like that. We've moved towards the allowance and the acceptability of Bluetooth technology for door locks, gate access, things like that. And the questions that I've had is, does a Bluetooth lock change my non-bailment status as a non-bailment operator? Do I take care, custody, and control of my tenant's goods by having a Bluetooth system where I can control the operation of the open and close of that door because I have the code somewhere to control access? The answer is no. I mean, I would tell you that there's really no difference between your external ability and a Bluetooth system to overlock or open a unit the same way where you could walk out on your properties now and put an overlock on a door or remove that overlock or even cut a lock of your tenant's unit. This is just taking away the contact, the touching part with respect to the locking system. So that's certainly something that seems to be a movement in our industry with respect to contactless elements of this, and I don't want people to be upset that they can't do that, that it will change their bailment status. Same thing is true with payment, moving towards credit card online payments in lieu of any personal or cash payments at an office. How does that work where your office is closed or you don't want to have contact with a customer to pay by cash? Can you convert to credit cards, knowing that there's a stress point out there, and we've talked about it before, that there are certain people that don't have access to credit cards, don't have checking accounts, and transact only by cash? Is it somehow discriminatory to people that are using only cash as their method of payment if you convert your system to a credit card operation type system? And the answer is no, especially now where there's this concern over the exchange of money and the virus being transmitted by money, whatever that might be. Your decision to move to a credit card electronic transaction, credit card or debit card transaction at your facility is fine. You do have to think about certain solutions for cash paying customers. And I've heard some great operator type solutions. If someone only has cash, can they then go down to a local convenience store and convert that cash into a debit card type payment and like a gift card type payment? The answer is yes. There are solutions in a cashless transaction situation or a cash transaction situation to make it cashless. So again, what I'm trying to make sure you feel good about is the fact that if you set certain rules in place at your facility with regard to payment via credit card or debit card, is that an illegal act? And the answer is no, but you have to be accommodating to those that are frustrated with the fact that they don't have access to credit card or debit cards or checks. So you can work through those situations. Of course, if someone could only pay you by cash, whereas normally you might take that and now you're requiring credit card, I would delay a lien sale as a result of that to allow someone to pay, sort of what we've talked about before is a bid and hold, where you take bids, but you'd hold the sale and the transaction for 7 days to allow someone to pay. I just want you to move towards the recognition that credit card payments would be legal in terms of a methodology of payment in your operation. And then lastly, what I wanted to talk about was the lien sale itself. Obviously, what we're trying to do is not have a group of people at a lien sale, at a live lien sale at your facilities as much anymore. The opportunity of gathering together to bid on a tenant's unit at a lien sale could potentially be a dangerous situation in the middle of the virus as we face it. So it's a situation where we want to move towards online lien sales. That's available to you in Arkansas. It's legal in Arkansas. It's a situation where you avoid the contact anxiety at a gathering of 10, 20, 30 people at your lien sale. It protects the manager at the facility as much as the people that are gathering for the lien sale. So this shift, again, one more element of technology to online lien sales. Is that legal? Does it work? I think if you talk to other operators within the association that are using online lien sales, you'd understand that it is a good solution relative to a foreclosure of the tenant's goods, that the bidding radius is greater based upon the fact that people can access your sale online as compared to having to come to your facility within a 5 or 10 mile radius, that people are bidding from a farther radius, that there's greater revenue involved with an online lien sale. And ultimately, at the end of the day, you're taking out that situation where people are live on your property in multiple numbers, which goes back to one of my earlier comments, which is a individual claiming virus contact at your facility will be very hard to prove from a proximate cause legal basis. But if you have 20 people at your auction and those 20 people contact the virus and come back to your facility, you have potential liability with respect to how your property was maintained. So my comment is, why put yourself in that situation? It'd be better for you to be thinking about online lien sales as a technological solution to that potential liability problem. So I talked about Bluetooth, talked about credit card payments, online sales. just want you to be open to the fact that your world is an oyster as it comes to self-storage. There's so many vendors, many of those who are sponsors of this event, that are out there doing things that move our industry forward. I don't want you to hesitate to move forward with them based upon the concern of legal liability or inability by statute to take those steps. We are constantly evolving as an industry. The virus and the world that we've lived in now with the pandemic, I think is going to force us to shift quicker. You need to be prepared to do that. I go back to your rental agreement. A lot of the things that we put in the rental agreement in the last couple of years gives you that opportunity to move ahead without having to do a redraft of your rental agreement. But if you haven't done an update of your rental agreement, the Arkansas Self-Storage Association rental agreement is there for you to use as a member benefit. It's a good document, sort of has all the bells and whistles to protect you as an operator. So it'd be something for you to go back and look at. If not, then make sure those 4 sections that I mentioned in my program are now included as part of your rental agreement going forward. I think it will help you a lot in your operation and something that will protect you down the road. I know that Shelley is gathering maybe some questions that some of you have, and I'll do my best to try to answer them over time. I appreciate you participating in the conference today. Hope you are all staying safe and doing well, and I appreciate you listening, and stay safe out there. Thanks.
Thanks so much, Scott. We really appreciate your work on our on the ARSSA lease, and we really appreciate you being here today. I will get these questions over to you later this afternoon.
Okay. Hope they're not too tough.
No, not the ones that have come in so far. No.
Okay, good. All right. Thank you all. Have a great rest of the conference. Appreciate being invited.
Thanks so much, Scott. Take care.
Thanks.
All right. So while